There are three opinions. I had requested Brother Justice Suryakant to prepare the judgment of the court. In the meantime, I received a judgment from Brother Justice J.B. Pardiwala, Jamshed Pardiwala, in a dissent. So then I thought that's an opportunity for me to not deal with the dissent, but sort of again place some few thoughts. So Justice Suryakant has authored an opinion for himself, Justice Sundaresh and Justice Manoj Mishra. Justice Pardiwala has authored an opinion for himself and in dissent. The majority of us have upheld the constitutional validity of Section 6A of the Citizenship Act 1955. Justice Pardiwala has held that Section 6A of the Citizenship Act 1955 is unconstitutional with prospective effect. I'll just read out just a few extracts. The challenge to the constitutional validity of Section 6A gives rise to the following issues. A, whether the grant of citizenships to migrants from Bangladesh to Assam was within the legislative competence of Parliament under Article 11 of the Constitution. B, whether Section 6A of the Citizenship Act adopts unreasonable cutoff dates and singles out the state of Assam, thereby violating Article 14. C, whether Section 6A can be regarded to be violative of Article 355 on the ground that the provision does not curb undocumented immigration, which amounts to external aggression. D, whether Section 6A is violative of Article 29(1) of the Constitution on the ground that Assamese cultural identity is lost as a direct consequence of granting citizenship to migrants from Bangladesh residing in Assam. E, whether Section 6A(3) of the Citizenship Act is unconstitutional on the ground of temporal unreasonableness. And F, whether Section 6A(2) is unconstitutional on the ground that it neither provides a method for implementation nor empowers the executive to implement the provision. Section 6A confers citizenship on those who migrated from Bangladesh to Assam until 24 March 1971. Article 6 and the proviso to Article 7 confer citizenship on a limited class. Section 6A deals with those who are not covered by the constitutional provisions, that is, those who migrated or re-emigrated after 26 July 1949. The provision also covers those who migrated in the period covered by the constitutional provisions, but who are not covered by the substantive stipulations in the provisions. For example, Article 6 does not cover a person who migrated from East Pakistan to Assam after 19 July 1948, but did not apply to register as a citizen before the commencement of the Constitution. Section 6A confers citizenship on such persons. There is a certain degree of overlap between Section 6A and the constitutional provisions. However, that does not amount to an alteration or amendment of the constitutional provisions. This is for the simple reason that Article 6 and the proviso to Article 7 confer citizenship on the commencement of the Constitution. That is, they deal only with who shall be citizens on 26 January 1950. In contrast, Section 6A confers citizenship from 1 January 1966 to those who migrated before that date. Those who migrated between 1 January 66 and 24 March 71 are conferred citizenship upon the completion of 10 years from the date of detection as a foreigner. Thus, Section 6A confers citizenship on a later date to those who are not covered by Articles 6 and 7. Section 6A could be interpreted to alter or amend Articles 6 and 7 only if it conferred citizenship retrospectively as at the commencement of the Constitution, which is not the case. The use of the phrases notwithstanding and shall not derogate from produce different effects. Article 11, when interpreted on the basis of the above analysis, produces the following meaning. A, the legislative competence of Parliament to enact laws related to citizenship is traceable to entry 17 of List 1 and not Article 11. And B, the provisions in Part 2 do not impact or limit the legislative competence of Parliament. Section 6A was included with the object of reducing the influx of migrants to India and dealing with those who had already migrated. The Assam Accord was a political solution to the issue of growing migration, and Section 6A was a legislative solution. Section 6A is one more statutory intervention in the long list of legislation that balances the humanitarian needs of migrants of Indian origin and the impact of such migration on the economic and cultural needs of the Indian states. Parliament, even before the enactment of the Citizenship Amendment Act 1995, has treated migration to the state of Assam as a cause of concern. Previous sections of this judgment trace the enactment of the Immigrants Expulsion from Assam Act 1950 and the IMDT Act which dealt with the specific problem of undocumented migration to Assam. The central government could have extended the application of the IMDT Act to any other state by a notification. However, no such notification was issued indicating that the immigration to Assam presented the Union with a unique problem in terms of magnitude and impact. Though other states such as West Bengal, 2,216 kilometers, Meghalaya, 443 kilometers, Tripura, 856 kilometers, and Mizoram, 318 kilometers, share a larger border with Bangladesh as compared to Assam, 263 kilometers. The magnitude of influx to Assam and its impact on the cultural and political rights of the Assamese and tribal populations is higher. The data submitted by the petitioners indicates that the total number of immigrants in Assam is approximately 40 lakhs, 57 lakhs in West Bengal, 30,000 in Meghalaya, and 3,25,000 in Tripura. The impact of 40 lakh migrants in Assam may conceivably greater than the impact of 57 lakh migrants in West Bengal because of Assam's lesser population and land area compared to West Bengal. Thus, the singling out of Assam is based on rational considerations. Similarly, the cutoff date of 25th March 1971 is also rational. Even before the enactment of Section 6A, the IMDT Act defined an illegal immigrant as a person who entered India on or before 25 March 1971 without travel documents. As noted earlier, the IMDT Act was not specific in its application to Assam. The enactment defined the phrase illegal immigrant for all states, though the central government did not extend the provisions of the Act to other states. On 25 March 1971, the Pakistani army launched Operation Searchlight to curb the Bengali nationalist movement in East Pakistan. The migrants before the operation were considered to be migrants of partition towards which India had a liberal policy. Migrants from Bangladesh after the said date were considered to be migrants of war and not partition. Thus, the cutoff date of 25 March 1971 is reasonable. Having held that both the cutoff date and the singling out of Assam is based on rational considerations, the next question is whether the yardsticks have a rational nexus with the object of the provision. The answer is in the affirmative, since the migration from East Pakistan to Assam was in great numbers after the partition of undivided India. And since the migration from East Pakistan after Operation Searchlight would increase, the yardstick has nexus with the object of A, reducing migration, and B, conferring citizenship to migrants of Indian origin. Section 6A would be under-inclusive only when all those who are similarly situated with respect to the object and on the application of the rational yardstick are not included. Similarly, the provision would be over-inclusive only when those who are not similarly situated with respect to these two parameters are included. That not being the case, Section 6A is neither under-inclusive nor over-inclusive. Article 355 casts a duty on the Union of India to A, protect every state against external aggression, B, protect every state against internal disturbance, and C, ensure that the government of every state is carried out in accordance with the provisions of the Constitution. All these three phrases feature in Part 18 of the Constitution, which deals with emergency powers. If the duty of the Union to safeguard states against external aggression is justiciable in view of Article 355, then petitions could be filed claiming that the Union has not appropriately dealt with any of the situations referred to in Article 355. It could also be contended that emergency powers ought to have been invoked by the Union to deal with the situations appropriately. Reading the duty in Article 355 into a right would effectively place the emergency powers with citizens and courts. Such a consequence would be catastrophic for the federal structure of the Indian Constitution and would subjugate the constitutional status of states. Article 355 cannot be elevated as an independent ground of judicial review in view of the purpose of the provision as a justification clause and the impact of such a reading on the federal framework of the Constitution. As a matter of constitutional principle, the mere presence of different ethnic groups in a state is not sufficient to infringe the right guaranteed by Article 29(1). Article 29(1) confers the right to conserve, which means the right to take positive steps to protect culture and language. The petitioners ought to prove that the necessary effect of the law that promotes the presence of various ethnic groups in a state is that another ethnic group is unable to take steps to protect their culture or language. The petitioner also ought to prove that the inability to take steps to conserve culture or language is attributable to the mere presence of different groups. The detection of the foreigner is an elaborate process that required the state to build manpower and infrastructure for its implementation. The legislature conferred the state with the duty to implement the provision after it had built sufficient infrastructure for the same. The purpose of Section 6A3 was to provide a long-term solution to the issue of the large influx of migrants from Bangladesh to Assam. It is true that one of the causes of concern which led to the Assam students' movement and culminated with the Assam Accord was a dilution of the electoral right of those native to Assam because of the inflow of migrants. However, the purpose of Section 6A3 cannot be limited to it. The objective behind the enactment of the Citizenship Amendment Act 1985 was to deal with the larger problem of whether Bangladesh migrants of Indian origin could secure citizenship in India. The objective of the provision must be understood in the backdrop of the Indian policy on post-partition migration and the Assam movement. The principle of temporal unreasonableness cannot be applied to a situation where the classification is still relevant to the objective of the provision. The process of detection and conferring citizenship in Assam is a long drawn-out process spanning many decades. To strike it down due to lapse of time would be to ignore the context and object of the provision. Registration is not the de facto model of securing citizenship in India. The use of the deeming fiction in Section 6A2 obviates the need for registration. The provision does not contemplate a registration regime for persons who fall under this category, similar to Sections 3 and 4 of the Citizenship Act. Section 6A2 cannot be held unconstitutional for the only reason that it does not prescribe a process of registration. So I've also come to the conclusion that the provision is constitutional.
Speaking on behalf of myself and my brother Justices M.M. Sundresh and Justice Manoj Mishra, we have also upheld the constitutionality of Section 6A. We have, based upon the arguments, divided the issues which came for our consideration in two parts: prefatory issues and then the challenges regarding constitutionality.